In 2026, according to a major national study of thousands of Americans, 56% of adults have none of the core planning documents. None. No will, no power of attorney, no healthcare directive. Nothing. More than half the country is walking around with no paperwork in place at all. And here's the part that surprised me most. That number isn't getting better. It's flat, year after year, even as these documents get cheaper and easier to create than ever. Awareness is up, action is not. And I understand why, honestly. These documents force you to think about two things nobody wants to think about: becoming incapacitated and dying. So we put it off. We tell ourselves we'll get to it. And then retirement arrives. The exact season of life when this paperwork matters most. And far too many people cross that line with a folder that's still empty. So today I want to fix that, and I want to make it painless. I'm going to walk you through the 7 documents you truly need before you retire. And I'm not just going to name them and move on. For each one, I'm going to tell you 3 things: what it actually is and does, in plain English, what the document itself looks like, its real parts, so it's not a mystery, and exactly what goes wrong for your family if you don't have it. Because once you can picture each one, the whole thing stops feeling overwhelming and starts feeling like a simple checklist you can knock out. Let me give you a couple to picture as we go. Call them Jim and Carol, both 66, about to retire, good people who've saved carefully, and who, like most of the country, have almost none of this in place. We'll see exactly where each missing document would leave them, and how each one protects them instead. Let's build their folder, and yours, one document at a time. Document number 1, the last will and testament, the foundation. If you get nothing else done, get this. Here's what a will actually is. In plain terms, it's the legal document that says who gets your things after you die, and who's in charge of making that happen. And let me show you what it actually contains, because people imagine something far more complicated than it is. A will has a few basic parts. First, it names an executor, the person you put in charge of settling your estate, paying your final bills, and distributing everything according to your wishes. Choose someone organized and trustworthy, because it's a real job. Second, it names your beneficiaries and spells out who receives what. Third, if you have any dependents who are minors, grandchildren in your care, say, it names a guardian, and this is the only document that can do that. And finally, it's signed by you and witnessed, usually by 2 people, sometimes notarized, according to your state's rules. And those signatures are what make it legally valid. Now, what happens to Jim and Carol if they skip this? If someone dies without a will, the lawyers call it dying intestate. The state steps in and distributes your assets according to a rigid formula written by the legislature, which may be nothing like what you wanted. A court appoints someone to handle your estate who may not be who you'd have chosen. Everything moves slower, costs more, and your family has no clear instructions in the middle of their grief. A will is you keeping control of your own life's work instead of handing that control to a courtroom. Please, if you have no will, this is the one to start with. This week, document number 2, the revocable living trust. Now, I want to be straight with you right away. Not everyone needs this one, and I'll tell you honestly who does and who doesn't. But for the right person, it's enormously valuable, so let me show you what it is. A living trust is like a container you create while you're alive, and then move your major assets into your home, your accounts. Here's what the document looks like. It names you as the person who creates it and, while you're alive and well, controls it. You don't lose one bit of authority. You can change it or cancel at any time. It names a successor trustee, the person who steps in to manage and distribute everything when you die or become unable to. And it names the beneficiaries who ultimately receive what's inside. The whole point of it is this: assets held in a properly set up trust skip probate entirely. That public, months-long, sometimes expensive court process a will has to go through. So your family inherits privately, quickly, and without the court taking a slice. Who actually needs one? If you own a home, or you want privacy, or you have property in more than one state, or a more complicated family situation, a trust is often worth its cost, which typically runs $1,500 to $3,000, versus a few hundred for a simple will. Who can usually skip it? If your estate is modest and straightforward, a good will plus the beneficiary designations we'll get to. may be all you need. And one absolutely critical warning: a trust only works if you actually move your assets into it. Retitling the house, the accounts. An empty trust is a useless box, and forgetting to fund it is the single most common mistake people make with this document. And let me clear up the biggest myth while we're here. For almost everyone, a trust is not about dodging estate taxes. In 2026, the federal estate tax exemption is $15 million per person, so that's simply not a concern for regular families. It's about avoiding probate. That's the real prize. Document number 3, the durable financial power of attorney. And I'm going to make a bold claim. For the season of life you're entering, this one may protect you even more than your will, because it works while you're still alive. Here's what it does. A financial power of attorney names someone you trust, called your agent, to manage your money and finances if you become unable to do it yourself. Here's what the document contains. It names you as the principal, names your chosen agent, and lists the powers you're granting them: paying your bills, managing your accounts, dealing with your property, filing your taxes, and the magic word in the whole thing is durable. That word means the document stays in effect even after you become incapacitated, which is the entire point, because that's exactly when you need it. Some are written to take effect immediately. Others, called springing, only kick in once a doctor confirms you can't manage on your own. Now picture what happens to Carol if Jim has a stroke and has no financial power of attorney. Their money is tied up in accounts with his name on them. The bills keep coming: the mortgage, the utilities, his own medical bills. But Carol can't legally access his accounts to pay them. To get that authority, she'd have to go to court and ask a judge to declare her husband incapacitated and appoint her as his guardian or conservator. An expensive, slow, painful public process at the worst possible moment. A durable power of attorney avoids all of it with a single signature made in advance. It is one of the most important documents you will ever sign, and most people don't have it. Document number 4, the Advance Healthcare Directive. This is really the medical partner to the last document, and it's often two pieces bundled together: a living will and a healthcare power of attorney. Let me break down what each piece looks like. The healthcare power of attorney, sometimes called a healthcare proxy, names the person you trust to make medical decisions for you if you can't speak for yourself. The living will is the piece where you write down your own wishes in advance. What kind of care you do and don't want if you're seriously ill and unable to communicate. Things like whether you'd want to be kept on life support or a breathing machine, or feeding tubes in a situation with no hope of recovery. Together, these two pieces answer the question: if I can't tell the doctors what I want, who speaks for me, and what do they say? And here's why this one is a gift of love, not just paperwork. Without it, if the terrible day comes, your family is left standing in a hospital hallway, trying to guess what you'd have wanted, and often arguing about it in anguish with no guidance from you. I've seen families torn apart by exactly that guessing. This document lifts that impossible weight off the people you love. It lets them honor your wishes instead of agonizing over them. Studies find that a large share of older adults facing end-of-life situations can no longer make their own medical decisions, which is exactly why writing it down beforehand matters so much. Do this one not for you, but for them. Document number 5, and it's the one almost nobody knows about, which makes it the sleeper of this whole list: the HIPAA authorization. Let me explain, because this one is small but mighty. There's a federal privacy law, HIPAA, that protects your medical information. It stops doctors and hospitals from sharing your health details with anyone without your permission. Wonderful for privacy. But here's the trap. That same law can block your own spouse or adult children from getting basic information about your condition when you're sick, because technically they're not authorized. A HIPAA authorization is a simple document that names the specific people you allow your medical providers to talk to and share information with. That's it. It just lists who's allowed to know. Why does it matter so much? Because your healthcare power of attorney only fully kicks in once you're declared unable to make decisions. But there are countless situations short of that. You're in the hospital, groggy, overwhelmed, but still technically able to make your own calls. Or you desperately want your daughter to be able to call the doctor and get a straight answer about what's going on. Without a HIPAA authorization on file, the doctor may legally refuse to tell her anything. This little document is what lets your loved ones stay informed and help you through a medical event. It costs nothing to add, it's often just a page, and it prevents an enormous amount of frustration and fear. Don't overlook it. Document number 6, your updated beneficiary designations. And I put the word updated in there on purpose, because this is where a shocking number of people have a silent problem. Here's what this is. Many of your most valuable assets don't pass through your will at all. They pass by beneficiary designation, your retirement accounts, your IRAs, and 401ks, your life insurance policies, your annuity, even bank and brokerage accounts, which can be set to payable on death or transfer on death. On each of these, there's a form where you name who inherits it. And here's the crucial part that catches people. That beneficiary form legally overrides your will. It doesn't matter what your will says. The money goes to whoever is named on the account. Now here's the alarming statistic. Only about 1 in 5 families has actually updated their beneficiary designations. Think about what that means. People have accounts still naming an ex-spouse from a divorce 20 years ago. Accounts naming a parent who has since passed away. Accounts with no beneficiary named at all, which then get dragged into probate. I have seen a life insurance policy pay out to an ex-wife instead of the current wife, because a form was never changed, and legally nothing could be done about it. So the document here is really an action. Pull up every retirement account, every insurance policy, every account that has a beneficiary field, and check who's named. Make sure it's filled in, make sure it's current, and name a backup beneficiary too, in case the first one is gone. 15 minutes of checking prevents some of the most heartbreaking, unfixable mistakes in this entire subject. And document number 7, the one that isn't legal at all but that your family will treasure more than any of the others, the letter of instruction, or what I like to call the everything document. This is not a legal document, it carries no legal weight, but it may be the most practical, loving thing on this whole list. It's a single organized document updated once a year that tells your family everything they'd need to know if you weren't there to tell them. Let me describe what goes in it. A complete list of your accounts and where they are, banks, investments, retirement accounts, your insurance policies, the mortgage and any debts, the location of your important documents, the will, the trust, the deed, the titles, and the key to the safe deposit box, your passwords, or where to find them, and your phone's PIN because so much of life is locked behind a screen now. The names and numbers of your key people, your attorney, your financial advisor, your accountant, and the human things, your wishes for your funeral or service, who to notify, and if you like, a personal letter to the people you love. Here's why it matters so much. All the legal documents in the world don't help if your spouse doesn't know the accounts exist, can't get into your phone, and has no idea what you would have wanted for your service. This document is the roadmap through all of it. It's the difference between a grieving spouse spending a frightening year playing detective through filing cabinets and a grieving spouse who has in your own hand everything they need laid out clearly. It costs nothing but an afternoon, and people tell me a note in their late spouse's handwriting became the most precious thing they owned. Don't skip the 7th document. It might be the kindest one of all. Now, those 7 are the core, the ones that protect you and your family through incapacity and death. But since we're talking specifically about the documents you need before you retire, let me give you a quick bonus. 3 more that are worth gathering into that same folder as you cross the retirement line, because they're the paperwork your new life will run on. The first is your Social Security and Medicare records. Before you retire, create your account on the Social Security website and print or save your benefit statement, the one that shows your exact benefit at different claiming ages. Keep your Medicare card and enrollment confirmations with it. This is the paperwork behind your monthly income and your health coverage, and you want it in one known place, not scattered. The second is your pension or annuity election paperwork, if you have a pension. Remember, the survivor election on a pension is often permanent and irreversible, so the document that records which option you chose and what your spouse receives after you're gone belongs in this folder where your spouse can find it and confirm it. If you took a lump sum or bought an annuity, keep those contracts here too. And the third is a simple personal financial inventory, a one-page net worth statement that lists your accounts, their rough balances, your property, and your debts. It's not a legal document, but it's the snapshot that makes everything else usable. Updated once a year, when you sit down to build your letter of instruction, This inventory is half the work already done. So let me gather all 7 together so you have your checklist. 1. The will, your foundation. 2. The living trust for those who need to avoid probate. 3. The durable financial power of attorney to manage your money if you can't. 4. The advance healthcare directive to name your medical voice and state your wishes. 5. The HIPAA authorization so your loved ones can get information. 6. Your updated beneficiary designations which override your will. And 7. The letter of instruction, the loving roadmap through all of it. Before I give you the honest caveats, let me handle the 2 questions everyone asks once they have the list. What order do I do these in? And where do I keep them? Because a document nobody can find is almost as useless as one that was never made. On order, if you're starting from 0, do them roughly in this sequence: the durable financial power of attorney and the advance healthcare directive first, because those protect you while you're alive and a crisis could come at any time. Then the will. Then check and fix your beneficiary designations, which is free and fast. Then decide with an attorney whether you need the trust. And finally, write your letter of instruction, since it pulls everything together. Don't let the size of the list freeze you. 1 document a month and you're fully protected within half a year. On storage, here is a tip that saves families real grief. Do not keep your original will and directives locked only in a bank safe deposit box. Here's the trap. In some states, when you die, the bank may seal that box until the court gives permission to open it, which means the very document your family needs to start the process is locked inside the box they can't get into. Keep the originals in a secure but accessible place at home. A fireproof lockbox is ideal. And tell the key people exactly where it is. Your executor and your power of attorney agent should know where these documents live and how to reach them. Today, not someday. Give your healthcare agent a copy of your directive and give your doctor one for your medical file. A document's whole job is to be found at the moment of crisis. Make sure yours can be. And review them every few years, and after any big life change, a death, a divorce, a marriage, a new grandchild, a move to a new state. Laws change, families change, and a 20-year-old document naming people who are no longer in your life can cause as much trouble as no document at all. Let me also name the 4 mistakes people make with these documents, because sidestepping them is half the battle. Mistake 1. Having no documents at all, the 56% problem, usually out of avoidance, not indifference. Mistake 2. Creating a trust and never funding it, leaving an empty box that does nothing. Mistake 3. Never updating beneficiary designations, so the money goes to the wrong person no matter what your will says. And mistake 4. Making the documents but hiding them so well that no one can find them when the moment comes. Avoid those 4, and you're ahead of almost everyone. Now let me be honest and careful with you, the way I always try to be. I am not an attorney, and none of this is legal advice for your specific situation. These documents, and especially the rules for making them valid, the witnesses, the notarization, the exact wording, vary from state to state, and getting the details right is what makes them hold up when they're needed. The good news is that getting these done is more affordable and accessible than most people fear. A qualified estate planning attorney can prepare the course set for many families for somewhere in the hundreds to low thousands of dollars, depending on complexity, and it is some of the best money you will ever spend, because it protects everything else. There are also reputable online services for simpler situations, and free or low-cost help through your local area agency on aging, and some senior legal aid programs. The point is not which route you choose. The point is to choose one and begin. Because let me come back to where we started, with that number. More than half of American adults have none of this in place, and the reason isn't that they don't care about their families. It's the opposite. It's that these documents ask us to look squarely at getting sick and dying, and that's uncomfortable, so we defer it, year after year, until it's too late to do it calmly. But here's the reframe I want to leave you with. These 7 documents are not about death. They are about love and control and peace. They are how you stay in charge of your own life and your own care. They are how you protect the people you love from confusion, conflict, and crisis at the worst moment of their lives. Every one of them is really a message to your family that says, I thought about you, I planned for this, I made it easier for you. Let me make the stakes real by showing you both versions of Jim and Carol's story, because this is what all of it comes down to. In the empty folder version, Jim has a serious stroke. Carol can't pay their bills because the accounts are in his name and there is no power of attorney, so she's in court seeking guardianship while the mortgage sits unpaid. The doctors won't tell their daughter anything because there's no HIPAA authorization. Nobody knows what Jim would have wanted for his care. So the family argues through their tears. And months later, when he passes, there's no will, so the state decides who gets what. The estate crawls through public probate, and Carol discovers his old 401k still names his brother from before they married. Every single one of those wounds was preventable. Now the full folder version, Carol steps in immediately under the power of attorney and keeps everything running. The doctors talk freely to their daughter. The family honors Jim's written wishes with peace instead of conflict. And when the time comes, everything passes smoothly privately to the people Jim chose. Same tragedy. Two completely different experiences of it. The only difference was a folder. So let me help you find where to start, because you shouldn't try to do all 7 at once. If you have nothing at all, like more than half the country, start with the durable power of attorney and the healthcare directive this month, because those protect you while you're alive. Then add the will. If you have an old will from decades ago and nothing since, your move is to review it and, more urgently, check those beneficiary designations, because they may be badly out of date. If you own a home and want to spare your family probate, your conversation is with an estate attorney about a trust. And if you've got the legal documents but your spouse has no idea where anything is or how the money works, your job is that letter of instruction. This weekend, find yourself in one of those, and you know your first step. So here's what I'd like you to do. Don't try to do all 7 this week. That's how it stays undone. Just do one. Pick the one you're missing most. For most people, that's the will, or that durable power of attorney. And take the first step. Call an attorney or start the form. Then next month, do the next one. And here's one more thing that costs nothing and matters enormously. Once the documents exist, have the conversation. Sit down with your spouse and your adult children and tell them, in plain words, that these documents exist, where they're kept, and who you've named for what. Tell them what you'd want in a medical crisis. It's an awkward hour, I know, but the research shows 1/3 of older families never have this talk. And that silence is where so much of the confusion and conflict comes from. The document is the legal half. The conversation is the human half. Done together, they turn a frightening unknown into something your family has already faced. Calmly, with you leading the way, that conversation may be the single most reassuring thing you ever give them. Knock them down one at a time, and by the time you're settled into retirement, that empty folder will be full, and you'll carry a kind of peace that most people never get around to giving themselves. You spent a lifetime building something worth protecting. These 7 documents are how you protect it, and the people you built it for.